This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawuna Matanda.
I'm BJ Lomsal.
And I'm Jennifer Raphael.
Today, we're bringing you some highlights from the 2025 Society of Construction Law Australia Conference, a two-day exploration of some of the most pressing issues and discussions in our industry today. First up, I sat down with Michael Bleby, a journalist from the Australian Financial Review, who has been writing about property for over a decade. He shared his thoughts on how to resolve the massive challenge on everyone's mind. How can we deliver the infrastructure needed for the Brisbane Olympics? Let's get into it. Michael, welcome to the show.
Thank you very much for having me.
Now, you've just completed a very interesting fireside chat on a wide range of topics. What surprised you the most about that conversation?
The thing that interested me most was when we talked about who should lead this project, which I found the most fascinating thing because there are so many whats and whys that need resolving. The who brought a really wide range of suggestions. There were some fairly way out ones, but of the more measured ones, they varied between people with proven political track records in working constituencies and making things happen, through to being successful sporting leaders, through to being solid construction people. All these types bring different skills. And I sort of think the conclusion from the session was that whoever is given the job of leading this infrastructure delivery is going to be somebody who can tie all those characteristics together.
I think you're right. Yeah, that was a really fascinating question and interesting to see all the different responses. Who would you have picked if you were part of the picking team?
Now you got me on the hop because I didn't actually think of an answer for that myself. I was too busy asking it of everyone else.
That's all right.
I thought Alicia Sheridan's suggestion of someone like Sally Ann Atkinson was very smart. A former Lord Mayor of Brisbane. She's local, but is used to working different types of causes, working different sides of politics, and would be somebody who could potentially pull the cart along to get it over the line.
And the panel had a really different mix of people from like transport, infrastructure, law. Do you think having that mix of voices led to a different kind of discussion?
It's the old idea of diversity. The wider the views, the more ideas you're going to get, and the more constituencies are going to be represented. Now, a project like Olympic infrastructure delivery has to be multidisciplinary. It's going to cut across everything from law, politics, construction, logistics, procurement, planning, legal. This one's got something in it for everybody. So yes, you do need to find a way to try and bring them together and make them work. So the more ideas, the better. But then you also need somebody who can at some point step in and say, right, now we're making a decision.
Yeah, I think that's the hard part, right? Having that democracy, but having someone that can sort of draw things in. And I mean, after that panel, what do you think the biggest hurdle for the Brisbane Olympics will be from an infrastructure perspective?
Look, I think these things always end up happening. Not as efficiently and not as cleanly as any of us would ever like, but they happen. And then at the end, we all enjoy ourselves for a bit and pat ourselves on the back before going on to the next one. I did really enjoy the question from the floor saying, how can we in some way bottle up the lessons that we learn from doing this project so that next time we're not starting from zero again and we're actually able to start from a step above so that we can make the next one and the next one and the next project more efficient.
And I think that's something that's sort of missing in infrastructure. We just delivered in Auckland a lessons learned on the last project that the client delivered, and they'd never looked back to improve their next project. So I think that reflecting, improving and learning from the past is critical to success.
I hope we can do it differently this time.
My final question is that you've been covering property in the Fin Review for over a decade. What's been the most interesting story that you've covered in infrastructure, property?
I think writing about property, it allows me to indulge my sort of inner policy geek. And one of the stories I've most enjoyed But one of the stories that's actually been possibly the hardest to report on was the whole issue that has arisen around combustible cladding and then defects in buildings. Because when you're reporting on stuff that's happened, it's at the end point of a process. And you've got courts, you've got lawyers, you've got contractors, you've got consultants trying to work out how the hell they're going to try and remedy this situation. And there are lots of arguments. But what that story actually showed me was the real victims in these were individuals who'd bought apartments and were now saddled with what was to be their home that was either uninhabitable or unsaleable because it was built so poorly. And it was possibly one of the most depressing stories I've had to do, because you would meet some of these people, and when the excitement of the court cases and the legal threats and the angry fists thumping the table is gone, you still got someone living in an apartment that is poorly built and they've got no way out of. And I think that's probably, in 11, 12 years of writing about property, the story that stayed with me the most.
That's a great answer. And thank you so much, from one Adelaide University alumni to another.
Are you?
I am. Thank you for taking the time out to come and have a quick chat. Thank you, Michael.
Thanks so much for inviting me. It's lovely to chat, Mona.
Next, I sat down with Mia Timpano, a former journalist and final year law student who describes herself as a construction law enthusiast. At the time of our chat, Mia had just finished moderating a panel on the future of construction law. She discussed something that every young lawyer is grappling with right now, which is, how can you use AI to work smarter without losing the fundamental skills you need to do a great job? Let's jump in. Mia, welcome to the show.
Thank you so much for having me, Moana. It's my pleasure.
That was a really fascinating panel you just moderated. You did an amazing job.
Thank you so much.
Now, Mia, you describe yourself as a construction law enthusiast, and I love that. Can you let us know how you got to that title?
Well, I stumbled into a Society of Construction Law Australia event, and it so happened that someone had sent me a flyer for an event and said, this might be of interest to you. And I walked in and I thought, this is absolutely fantastic. The legal issues that were being discussed absolutely lit me up. I loved the complexity. I like contractual issues as well. It's an area of law that interests me. The nature of the disputes I find very interesting. The nature of the projects are not only impressive, but they're so integral to our society. And even last night I was just watching SBS old doco on ancient world architecture and infrastructure, and I thought, actually there's a lot of interesting questions from an infrastructure perspective at all junctures of history. So as a history buff as well, there's plenty to get excited about. There are so many interesting aspects of construction law. Today, hearing from Sean Brady, an amazing presentation on engineering. I'm not an engineer, but how fascinating. These are such riveting topics because, yes, there's the technical side of it, but asking why.
No, I absolutely love your enthusiasm, and I think it's contagious, and I'm probably enthusiastic enough already. And are you a front-end or back-end lawyer, or are you sort of generalist at the moment?
I'm a final year law student, so I'm not in practice as yet.
Have you got an inkling of which way you might want to go?
I've enjoyed absolutely everything that I've been exposed to so far, so we shall see.
It's good to keep an open mind, like you said before, and be patient with yourself.
Absolutely.
What were your key takeaways from the discussion today?
My key takeaway is that a lawyer is always learning and to always be alive to the way that things are changing and to embrace that change, to lean into it and to be thinking critically about how you can be working to the advantage of your firm and your clients, but to always actively be learning. I think that came across very strongly.
Yeah, there were definitely a lot of comments about that continual development and continual learning. Was there anything that surprised you from today's panel?
Because I'd had such extensive chats with the panel beforehand, I must say no. Not a lot of surprises, but I would say that I learnt a lot over the course of delving into the experience of the different panel members and learning about the ways in which things do change, but also the ways in which things remain the same. In the sense that, for example, as Philippa Cole and to some extent the rest of the panel acknowledged, there are core skills to being a great lawyer that don't change as well.
So Mia, the panel you just moderated was a YCC panel. So what is that for people that don't know?
YCC is the Young Constructors Committee, which is for the junior members of Society of Construction Law Australia. That includes students and also practitioners in the early years of their career.
And one of the things that was really topical with this panel was AI. And I was very interested in discussions about how we balance using it to be efficient and effective while still getting new skills. So not getting de-skilled because now the AI is doing all the heavy lifting. Have you got any thoughts about how we strike that balance, or how do you strike that balance in your own life?
I don't have the answer yet, but I was inspired by something that Philippa Cole or Pip said on the panel, or rather that we discussed over the course of preparing for the panel, and I do think we touched on to some extent, which is the importance of building your hard skills and not relying on AI to learn how to write, to learn how to draft, to become the expert in the words that you're using, and that will enable you to remain in the driver's seat so that when you are using it as an assistant, that you are able to maximise the benefit of it.
I think one of the panelists talked about putting your draft through and getting critical feedback, and I think that's a better way sometimes to make sure you actually do the hard work yourself, get some feedback. It's almost like having a coach going, well, hang on, this argument is weak. Can you sort of improve that? Were the panelists from the same sort of cohort, or are they, let's say 5-year plus lawyers or 10-year plus lawyers?
Everyone was under 5 years of experience. So Young Constructors Committee includes people who are both students and people who are early in their careers. So everyone on the panel was a very early career practitioner, but up to 5 years.
Wow, well, even more impressive given how young they are. Turning now to emerging industry challenges, the panel explored new challenges reshaping the industry. Which issues seemed most pressing to you?
Certainly AI, and I think for me, better understanding the green energy transition certainly was something that struck me as critically important to understand, what are the issues with respect to these projects.
Yeah, and I think with AI, the conversation was very interesting around how we strike that balance between sort of using AI for these efficiencies, but while training junior lawyers and ourselves sort of staying trained in our grassroots abilities. Have you got any thoughts of how we strike that balance between being quicker, faster, but not losing sight of developing our skills? Or how do you strike that balance in your own career between using AI and trying to do it yourself?
Keeping an open mind. I think that it's good not to make assumptions about the technology, to think critically about it, but also to keep an open mind with respect to how it could potentially be helpful. I think that open mind is central to engaging with it effectively.
And how did the panelists' views differ from what you expected before embarking on this journey?
As a law student and a construction law enthusiast, I was really soaking things up. So I didn't have very strong expectations of what people would necessarily be bringing to the panel.
Are there any insights from today's panel that made you reconsider how you will approach your practice going forward?
I think I will be very deliberately trying to acquire a breadth of skills in order to be able to come into the different legal challenges with a really strong base. What I found particularly interesting was the need to be across so many different areas of law in order to be an effective construction lawyer.
And I guess talking about diversity of experience, you've obviously got this amazing background in journalism. I saw that you reported on New York Fashion Week. Amazing. How was that?
I cannot tell you how wonderful and amazing and otherworldly that experience was. It was absolutely wonderful.
And what do you think the value in bringing different backgrounds to the law is, not just being sort of a straight law student who studied law, nothing else, and come to the law?
I'm so grateful for having another career coming into this because I have the benefit of understanding another business, another industry, and being able to compare and contrast the challenges. And I think having a background in working with clients as well is indispensable. But I also like that they have been relationships of a different nature as well. So there's the opportunity to perhaps think creatively with the benefit of this other experience.
I totally agree. I mean, I've got a background in psychology. So I think having that different hat on that you can put on sometimes can be handy. Other times, I think it can be risky when you sort of are looking at things with a different lens. But yeah, it's a good balance to strike. And based on today's discussion, what skills do you think are most important for the next generation of construction lawyers to have?
I think having really great human skills, relationship skills, will be indispensable no matter what comes our way. And being able to think creatively, being able to communicate well, and to be able to anticipate problems, I think those are the skills that will be important. Whilst they aren't technological skills, I think they are the skills that will perhaps help drive to successful outcomes and can help us drive our technology as well to make sure that they're ultimately working for us. Technology is a tool, and if we can stay in the driver's seat, then we can get the most out of those tools.
No, absolutely. I think soft skills are essential wherever you find yourself, whether you're doing journalism, psychology, or law. Like I said earlier, you did an amazing job facilitating that discussion. Did your experience in mooting and being a moot coach come in handy today?
Absolutely. I think one of the greatest benefits of mooting is facing the fire of tribunals or acting tribunals and dealing with a barrage of questions anticipated and unanticipated and contending with that audience certainly has built my capability to deal with an even larger audience.
That definitely comes through. And what advice would you give to young lawyers coming through, or what advice would you give your younger self?
Be patient. Things that are hard today aren't going to be so hard tomorrow because you apply yourself to the problem, you learn, you get better, and you get exponentially better over time. So go easy on yourself. It'll come.
That's great advice. Mia, thank you so much. I know you had an hour on stage with that panel and you've come straight here. So thank you so much for taking the time to talk to us today. We really appreciate that.
The pleasure is all mine. Thank you.
And finally, I caught up with Harris Ashton. Harris is the winner of the 2024 Student Brooking Prize for his paper, Illegality in Quantum Meruit and Residential Construction Law. He explained why homeowners are turning to the kind of illegal contracts with builders that can leave them completely unprotected when things go wrong, and what needs to change in the law to level up the playing field. Let's have a listen. Harris, welcome to the show.
Thank you.
And congratulations on being New Zealand winner of the Australian Booking Prize. How do you feel getting recognised for your work in this way?
Well, it was really nice. I didn't set out to go and win this prize by any means. I was pretty supported by Matthew Bell and his subject. He pushed us. He told us, if you got a good mark in this paper, why don't you try and submit it? So it was a nice surprise when the email came in on a random morning saying, oh, you've won.
Oh, excellent. And for those who've missed your talk, could you briefly tell us what your paper is about?
Yeah, so the formal title is Illegality in Quantum Meruit in Residential Construction Law. And the real short summary there is that in many cases, a builder who has an illegal contract with a homeowner is still able to pursue recovery and restitution for a quantum meruit. And I just don't think in residential construction law that sets the balance just right.
And what sparked your interest in this particular area of law?
Well, I've always been a fan, controversially, of equity and equitable remedies, and I know that's the real nerdy law hat going on there.
Definitely.
My colleagues are sick of hearing about my reckons on equity, but residential construction law is incredibly important in Australia. I mean, most of us live in a building, we work in buildings, and the way those buildings have been built is underpinned by construction law. And it's important just to be quite critical about the systems and processes that enable housing to be built.
No, I was very impressed by how, I guess, analytical and critical you are of the sector, especially at such a young age. So that was very impressive. Moving on now to some of the key issues in construction law. Now, you talk in your paper about homeowners being unsophisticated. What do you mean by that in everyday terms?
Well, I said that as a bit as an offhanded reference to a LinkedIn post I saw. But unsophisticated is not meant as a slight, but it's a recognition that builders are technical experts or that homeowners aren't often aware of the construction law that underpins contracts. So as everyone knows, cash jobs are very common. The idea of, we don't need a contract, that's very common. But builders typically, or we should expect of them, to know better than homeowners to engage in that conduct. So on the flip side of, if I was to say homeowners are unsophisticated, that most builders are or should be sophisticated.
Yeah, it's amazing. I mean, I guess as a commercial lawyer, I'm shocked that they actually, things that happen like construction without any contract. So do you know if that happens often or?
Well, it's typically for renovations is what I've seen. So, a bathroom job, the builder will say, we'll just do it under the table. So it's those smaller jobs that it's much more common.
That makes sense. And how does the law currently handle when a contract, I guess, is found illegal in this context?
I mean, they're one step beforehand of finding it illegal, and the law is often reluctant to find a contract to be unenforceable. I mean, contract law's default position is to make a party's agreement enforceable and just cut out the little bits that don't work where possible. And so it's a high bar to reach illegality, but when an illegal contract is found, the typical position is that it's void. So it's as if it never happened. So if you're familiar with the doctrine of mistake, it unwinds the contract. And so maybe you've already paid money as part of the contract or have done work, but you can't further rely on the contractual right. So there's no rectification under a void construction contract. There's no contractual right to rectification or liability for defects in that way.
Right. And how does this affect, I guess, your mom and pop sort of home builder in real life? What's the key takeaway I should be telling my parents?
Try and have your contracts in writing. I mean, because you can't, if a contract is found to be unenforceable, it means you also can't require the builder to complete the work, for one, or if the work has defects, they're not able to rely on the contractual provisions, if there are those, for defects.
Now, talking a bit about your solutions and the future directions you sort of discussed today, between the UK, New Zealand and Australia, which elements do you think work best for protecting homeowners?
Well, so of course I've got a bit of a home bias with New Zealand, but I like that the UK, when thinking about whether remedy is still available, considers a range of factors approach. So it's both taking into the underlying purpose of the statute, but also thinking about the bigger picture of whether precluding recovery or enabling recovery is just unfair for one. So I read the quote from Lord Tolson of the UK Supreme Court about that we should not allow illegality to give with one hand and take with the other by making a contract unenforceable, but also thinking about what then is sort of the flow on to equity. And so in New Zealand, the position is established in statute, and I think with Australia's legislative environment, change does need to come from the parliaments, but luckily, at least at the time I was writing it, there was a lot of reform afoot in the domestic building contract sphere in a lot of states and territories. And I just think when these opportunities for legislative reform come up, parliaments should be maybe a little bit more interested in thinking about the bigger picture and all the exact consequences.
Yeah, no, that's a really good point. And I guess in your work in VCAT, have you seen these sort of issues playing up, either specifically on the topics you discussed or just generally, like what are the key issues you were seeing that need to be reformed?
Well, so I can't comment too much about any cases before VCAT.
Yes, of course not. Just a general gist.
The general gist is, there's a lot of unwritten agreements with builders, and often homeowners are quite surprised about what the law actually is and their remedies under the law. And so I think maybe partly there should be a bit more awareness with homeowners as well about the risks involved in going under the table and what that means for contractual remedies, and it doesn't really affect the statutory remedies, but...
Yeah. Now, you sound like a really future-thinking, problem-solving, impressive young man. So what would you change about our legal system in terms of how it handles construction disputes, if you could change one thing?
Well, construction disputes are very legalistic, and you go back and read some of the original vision for particularly state tribunals for domestic building. They talk about the idea of a decision maker being able to go out to a house and decide on the spot with little expert evidence and without incredibly complex legal argument. I think we just need to take a little bit of oxygen out of the legal fires, I think, in construction disputes when they run too long, and ultimately they put people's health and safety at risk the longer these disputes run. And so, unfortunately, maybe this is self-defeating. Taking lawyers a little bit out of the picture is...
True. I get that. So in terms of the LinkedIn post that inspired your unsophisticated homeowner tagline, can you tell us a little bit more about that post?
Well, so I saw that post from the former New South Wales Building Commissioner, David Chandler. And if you're familiar with his social media presence, he's not afraid to tell her how it is.
Yeah.
And that's refreshing. And I know he has a lot of respect within the building industry itself, amongst non-lawyers. And he recognises that builders, bigger and smaller, are in a privileged position often. And I know there's a lot of stress in the industry, but that doesn't give them an excuse to take advantage of homeowners. And so maybe unsophisticated is a bit of a blunt way of putting it. But it's a nice reflection.
I mean, that term, we have that term in commercial law in terms of banking contracts.
Yes.
If you have unsophisticated customers, you have to give them just more detailed terms and conditions. So I think, I don't think it's derogatory. It makes sense.
Yeah, I'm glad you agree then.
Yeah. Well, thank you so much for coming on the show today, and congratulations again on winning the Brooking Prize. And also, I guess, for being the first speaker at the conference. You did a really great job. Thanks, Harris.
Thank you very much.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career, with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au.
This show was produced with strategy and production support from Wavelength Creative.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Moana Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.